Hello and welcome to this fourth video in a series of 10 produced for the Reveal project. And in this video we're going to focus on ethics, privacy and libraries. The Reveal project stands for Reinforcing Ethics and Values for Effective Advocacy for Libraries, and it was funded by CILIPS Research Fund. The aim of the project is to enhance collective advocacy across the profession through an accessible framework for library and information ethics and values, presented as a set of continuing professional development tools. And the videos that this one is part of form part of those 3 training materials. And as I said, this is the 4th video in a series of 10. You can see the other topics for the videos. So again, as I've said in previous videos, you can watch all of them or dip in and out of any one or few if you fancy. There is no requirement to watch one video before watching any other. So let's begin with the definition of privacy then. Supreme Court Justice Louis Brandeis, in the case Olmsted versus US in 1928, defined privacy as the right to be left alone, the most comprehensive of rights, and the right most valued by a free people. So you'll often hear that definition of privacy used. It's quite a classic one that is popular as a good summary of what privacy means in the modern era. Essentially, privacy is the right to be free from unwanted intrusion and to keep certain matters from public view. As such, it's a crucial aspect of personal autonomy and a vital component of individual fulfilment. And as such, it's heavily favoured by those who believe in freedom as an approach to social justice. So those who would call themselves liberals, for instance, or believers in human rights are very much in the stable of backing privacy. But it's important to note here as well that privacy is also complex. It can be a claim, it can be a right, an interest, a value, a preference, or merely a state of existence. And that quote's from Hill and Nissenbaum. So it can be quite a complex concept for people to understand. Most of us feel we have a feel of what it means. But in actual fact, it's something that actually really does compel organisations and professionals to be mindful of other human beings and how what we do might impact on their privacy, and conversely, how we can actually support that privacy claim. So in terms of privacy in libraries, we'll come back to a couple of examples of this later, but what's important to begin this discussion is to note that privacy really does fit in our professional space. There are 2 key aspects of privacy. Firstly, informational privacy, which is information about citizens, how it's shared, how it should be protected, and what rights citizens have or should have to that data. So that obviously is a privacy aspect that affects every organisation and includes issues like data protection law and the like. But also, importantly for libraries, is the notion of privacy and access. So therefore, what rights should citizens have when accessing knowledge? And what limits should be placed on such access? And again, I'll have some examples of that later for you to consider. And obviously one of the issues around privacy that we have to be mindful of is the notion of surveillance. And really surveillance is something that is arguably necessary to prevent crime, etc. And the big question really is how you balance national security versus the right of privacy of citizens. And as a profession, we must be mindful of the chilling effects of laws, actions or activities from both state and non-state actors that can be modifying the actions of others. And the notion of the chilling effect in law is essentially what that means. The idea being that a law is introduced that actually chills people's behaviour. Something that they thought was perfectly fine before the law came in becomes something that they try and avoid because they're worried about being discovered. So obviously it's important to note that governments can chill the rights of citizens through sloppy legislation. But from our standpoint, professionals can also do so through sloppy practice and procedure. So it's important to make sure that the systems that we use protect the privacy of our users, and that also when we're asking them to sign up to those services, that they are ethical. Legal is one aspect of this, obviously, but they also must be ethical from the point of view of a librarian. Now, privacy is a human right, it has been recognised as such, And the definition from the Universal Declaration of Human Rights states that no one shall be subjected to arbitrary interference with his privacy, family, home or correspondence, nor to attacks upon his honour and reputation. Everyone has the right to the protection of the law against such interference or attacks. But in reality, how is privacy in the modern age? Well, it's under threat from various areas. Obviously, the most obvious aspect of this is the easy exchange of data in the information society. So the fact that basically data about us can be, sent at the click of a mouse around the world. Our systems that monitor perhaps borrower behaviour or internet use, etc., all record essentially behaviour about people and what they do in their daily lives. And that data can be easily exchanged. So that's a concern. Another concern is the growth of profiling for commerce and services such as social media and free email. So again, people's behaviour, their comments, their views are all essentially being profiled for the benefit of others and not the individuals concerned. And obviously, importantly, lastly, the increasing interest in our lives from governmental organisations. Again, we must always be mindful of that in terms of people's privacy as well. And what attitudes to privacy might prevail? Well, they're essentially, as I said earlier, this notion of preserving a balance between civil liberties and prevention of crime. Very important. And one approach is the laissez-faire approach, which says if you've done nothing wrong, you've nothing to worry about. And the second, famous quote from Ben Franklin, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Now, it's important to note there isn't any one right or wrong answer to this notion of privacy, which one you fall down on, or if it's any others. It's obviously an ethical issue, one that's personal, but from the point of view of understanding how other people approach it, it is a good idea to get a feel for the different views on privacy that exist. Now, privacy and autonomy, as I mentioned earlier, is very important. Privacy is the right to be free from unwarranted intrusion and to keep certain matters from public view, as I said earlier. And Wax suggests that privacy encompasses the desire to have personal space, where we can freely express ourselves without the intrusion of others. So as such, it clearly plays a crucial role in individual autonomy. For example, the ability for you to seek out knowledge is often dependent on privacy. If you wish to find out something, a piece of information that may or may not be personal, then privacy is a big part of that. You don't necessarily want someone looking over your shoulder when you're looking for information. That will feel obviously intrusive to you. And as Griffin has observed, frank communication needs a shield of privacy. It needs the restraint of peeping toms and eavesdroppers, of phone taps and bugging devices in one's house, of tampering with one's mail or seizure of one's correspondence. So obviously a lot of those examples fall outside of what libraries do, but again it's important to recognise privacy in the round as a whole. What are the expectations of citizens with regards to privacy, and how can we help support those? Now, Raymond Wax has identified 7 shortcomings of privacy, which are useful for you to reflect on how privacy is perceived in the modern age. So, go through each one. First, privacy is often perceived as an old-fashioned value, an air of injured gentility. And you can certainly see that's the case the more and more technology we introduce in our lives, the more apps, for instance, we use for various things, the more that we're essentially asked to trade privacy to make our lives easier. So the idea of privacy is that it's essentially old-fashioned, something that we really shouldn't expect in the modern age. Second, privacy may conceal genuine oppression, especially of women by men, carried out in the private realm of the home. So again, the idea of privacy being left alone means if you're left alone, you can actually harm other people. So it is a good value, but it's also a value that can be used to hurt. Third, it may weaken the detection and apprehension of criminals. Again, similarly to the point above, privacy, if it's completely left to your own devices, then you are, in theory, able to harm other people via planning crimes and the like. Fourth, it may hamper the free flow of information, impeding transparency and candour. And again, that's really unarguable. If you're basically locking information off, for whatever reason you're doing so, it means that basically transparency isn't necessarily the first thing on your mind. So no question there that certainly privacy can restrict flowing information and people having access to it. The fifth, it may obstruct business efficiency and increase costs due to the necessity to adhere to standards in the collection of personal information. And again, that's certainly true. Data protection law basically compels organisations, both public and private, to do certain things with people's data. That has a financial implication. Number 6, from a communitarian point of view, privacy is individualistic and trumps community values. And again, that's certainly true. Privacy is very much an individual human right. It's hard to argue for privacy for groups or for communities, because obviously groups and communities are made up of individuals who have their own interests that they may wish to keep private. So again, point 6 I think is arguably true, that communities and societies may well suffer if privacy is not balanced in the right way. And the last point, withholding unflattering personal information constitutes a form of deception. So again, this is essentially getting into the whole area of the right to be forgotten. The idea that basically if you're holding back information about yourself that is pertinent to perhaps other people's interactions with you, or services provided to you, or employers employing you, then essentially what you're doing is deceiving people. So all of those 7 shortcomings I think are worth thinking about in terms of how you might perceive privacy. You may agree with all of them or none of them or some of them, but they are good ways of thinking about privacy in the round. Now, as I said earlier, if an individual is seeking to commit a crime or a terrorist act, then arguably privacy affords him more opportunity to do so. So that's just one example of where there's an essential tension between a right to privacy and where it may potentially be curbed. So privacy, for that reason and other reasons, is a qualified right. And what is the qualification? Well, under the European Convention on Human Rights, privacy is recognised as a human right based around the respect for private and family life. The qualification made to this is that governments can only interfere in accordance with the law and is necessary in a democratic society. And the reasons they can interfere with privacy: in the interest of national security, public safety or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, and lastly, for the protection of the rights and freedoms of others. And this leads us to consider more the privacy issues specifically in libraries. In 2015, Kobe Shimbun published some of the childhood library borrowing records for acclaimed author Haruki Murakami from his time when he was at secondary school. Now, Kobe Shimbun is a Japanese newspaper. The records that they published gave an insight into the reading undertaken by the young author, and the argument posited by the newspaper was that given he was such a significant cultural figure, the knowledge of what he read was of cultural importance and therefore in the public interest. Japan Library Association member Yoshihiro Nishigochi quoted as saying, "It's not right if people cannot use a library free from anxiety." And what Yoshihiro was basically highlighting here was this notion that people expect when they borrow books that their data will not be published, that people won't be made aware of what that person is reading without their permission. Now, the defence provided by the newspaper could be argued as being valid from the standpoint of a greater good. Arguably, knowledge of the kind of reading that formed a cultural icon's literary education, allowing society to understand what some of his influence may have been. So, it's a perfectly logical argument. However, it's also important to counter that by saying, as we go through life, we may read something that could be regarded as distasteful to gain an insight into a viewpoint. We also may read something that forms our opinions at a point in time, but we completely change our view on it when we read something else. So for that reason, it's really important that people should be able to read materials, if they're legal, obviously, should be able to read materials without really worrying that other people are looking over their shoulders doing so. Because going back to that notion that we mentioned earlier of the chilling effect, would we read such materials if we knew that the reading of it would be revealed to the public? So this was quite a famous case when it happened a few years back, because it really does touch a raw nerve for a lot of librarians, this idea that borrowing records are essentially sacrosanct and shouldn't be made available without due process in law, and certainly should not be leaked to newspapers 20 or 30 years after the person has left school. Now, another well-known case from a bit further back was the John Doe librarians case, which happened in the USA. And in this case, 4 senior library professionals in Connecticut raised a case against the government over the legality of the Patriot Act in 2005-2006. And they challenged an FBI request to provide statistics on internet use from one of the library terminals in their area. Because under the provisions of that particular act, they were gagged about talking about the fact they'd even received a request. And the request was for a number of machines, a number of library terminals to see what people had been using that day on those machines. Now, the idea obviously of this is that you would object to this from an ethical standpoint because most of the people using those PCs, if not all of them, were basically going about their daily business, not necessarily doing anything harmful. So what you would be really querying here is why, if you have a concern about one individual, why would you not come with a court order for that one individual? Why would you have a fishing expedition that actually meant that no one, in theory, could use the library internet terminals without the fear of their data being handed over? So it was an important case from the point of view of how we protect the rights of users who use internet terminals. And this brings us really to kind of talk about data protection law. So obviously the Reveal project's not talking about laws specifically because they change so much, but really a little overview of why data protection law exists is useful to reinforce our understanding of privacy and why it matters. So why do we need data protection law then? There was an increasing concern from the mid-1960s onwards with the usage of data processing tools that stored data on individuals. By 1975 in the UK, the government had 220 functions that involved electronic processing of citizen data, including information on teachers and pupils, police records, DVLA records, and census information. And that data is from a government white paper called Computers, Safeguards for Privacy way back in 1975. So there was a concern even before the first Data Protection Act came in the mid-1980s that something had to be done to protect people in terms of what data processing could do in terms of harming them. And what are the concerns? Well, electronic systems could store and categorise information on people. These systems could link and provide profiles, as I mentioned earlier, of people that they had not consented to create. So you would fill in data for one thing, fill in data for another thing, and then organisations would combine those data sets to actually create a profile of your behaviour. And this led to the concern with the emerging concept of informational privacy, which I mentioned earlier, whereby people should be guaranteed rights over information about themselves and how it was processed. So again, this is a relatively new aspect of privacy, this idea of informational privacy, rather than privacy to be free to go about your daily business. This idea that the data about you is actually a part of you, it's important in terms of your identity, and obviously, arguably more importantly, it could be used against you. So what are the broad aims of data protection law? Firstly, they have to clearly define the subject rights, place restrictions on what data controllers and processors can do with the subject's data. Now, a data controller is the person that you would have the contract with. So, for instance, a library borrower would see the data controller as the library. Now, the library may well essentially have some third party providing the data processing for them, and that would then be the data processor. So, the example, for instance, of the libraries who have library management systems that are stored in the cloud. So no longer stored on their premises, they're using the provisions of the library management system companies and storing library management data on their servers. So the library is a data controller, but the third-party library management system company would be the processor. So it's important in law that people are protected at both ends. Ultimately, the data controller is the person that the citizen or the borrower has a contract with. They are responsible for the person's data. But the processor often does the work for the data controller, and therefore they also have to be liable as well. Another aspect of data protection law is that it defines kinds of data, especially around sensitive personal data. So obviously that gets into areas like health, sexual information, political background, etc., etc. And lastly, they specify sanctions and punishments for breaches. So it's not the purpose of this video to get into what data protection laws currently are and how they sit, because it would instantly date the video. Obviously, from your own background, you'll have perhaps undergone training around data protection law, GDPR, etc. It is important to keep up to date with law in this area, but it's important as a starting point to understand why the laws exist in the first place and what the laws are trying to do. So just summarising our discussion then. Privacy has been identified as a fundamental right, although it is one qualified by other interests. Obviously, a lot of the emerging services we see on the internet, including things like storing data in the cloud, challenge assumptions around privacy. And that might be okay, but equally it's something that we always have to be wary of and consider. And as a profession, we need to reinforce and champion privacy rights that are legally available to citizens. As you will know, it's part of CILIPS framework. For those of you who've watched the previous video where we discussed it, privacy and confidentiality are a part of our ethical framework that we are essentially charged with protecting. So privacy is an important aspect in librarianship. It's an important aspect both from the point of view of people's informational privacy, their data, and also important from the point of view of people being able to seek out information, read books, read material that essentially is something that they want to do for whatever reason they want to do it. As long as it's legal, we should try and aid that as much as we can. So privacy essentially allows people to read things that they might not want to be seen to be reading. And ultimately, that's something we should try and support as much as we can. So in the next video, we will focus on a linked right to privacy, the right of freedom of expression. And freedom of expression links with privacy because obviously part of freedom of expression is the freedom to seek out information and try to read material that perhaps other people might not want you to read. So I look forward to seeing you in that video.